first, the information and material in this presentation is, of course, for general informational purposes only, and it does not cover all the issues related to the topics discussed. This presentation is not intended to provide legal advice, and as such, the content does not constitute legal advice. Use of this presentation does not create any attorney-client relationship between the participants and the firm and or me. Okay. So welcome to the second week of our entrepreneur boot camp. Today I'll be talking about legalizing a business in Texas, and we have three objectives for tonight. The first one is to identify the common types of business structure. We will also learn how to register a business in Texas and understand the importance of legalizing a business. So we are here not to talk about or determine which business is the best for you. We are also not here to discuss which business is the best in terms of avoiding liabilities and taxes. So we're here to talk about how to legalize your business in Texas. Just want to make sure it's clear, because this could be a very broad topic, and our 1 hour is definitely not going to be enough to address all the possible issues related to this topic. Okay, so let's start with identifying the common types of business structure in Texas. And I said common types because this is not an exclusive list. There are more, but we're just going to be talking about this as part of our discussion for tonight, because I believe that these are the most common types that I usually encounter whenever I talk with clients about forming a business here in Texas. Okay, so of course, the decision as to which type of business you would like to put up is the decision that you have to make after consultation with your attorney or accountant. So let's go ahead and talk a little more about this types of business structure. So for sole proprietorship, definitely from the word sole, we're only talking about one person starting a business here in Texas. So it's supposed to be an individual, natural person when we say sole proprietorship. So basically, it's just, let's say you starting to transact business with another person using your name and paying taxes. So you already created sole proprietorship, or you already form a sole proprietorship in that matter. The other type of business entity is corporation. When we say corporation, I want you to think about C corporation and S corporation, which we will talk in the next slide. But for now, I just want you to know that when you say corporation, you are actually forming a different entity, separate and distinct from you, the person who are creating the corporation. And in that case, we will talk about a shareholder and, of course, the board members in a corporation. So just so you know, when we say corporation, it is a separate and distinct entity from the owners of the corporation. Now, for general partnership, from the word partnership, it means you need to have at least two persons coming together to transact business together. Now, I said general partnership here because in general, that's how you form partnership. Two people deciding together to form a partnership. Now, this is a default partnership. You don't have to do anything. You just agree with each other that you form a partnership. You don't have to file anything. You already created general partnership. And there is this so-called 5 factors that the court will determine if in case you're sued as to whether you are general partnership or not. The court will apply the 5 factors, and I use the mnemonics, PICLC. So the P is for profit, the I is for, and we'll talk more about this in the preceding slides, or succeeding slides, sorry. So P is for profit, I is for intent, C is for conducting business or control in the management, L is for losses, and C for contribution, either money or property. So those are the factors. Now, the next one is the limited partnership. So again, this is a partnership, which means that it has to be created by or formed by 2 or more persons. It's limited partnership, which means that there must be at least one general partner and one limited partner. So it has something to do with liability. Why do we have those kind of designation? So general partner can be personally held personally liable for the transaction of the partnership. But for limited partners, their liability is only limited as to the value of their shares in the partnership. So that's why we have the general partners and the limited partner. Now, if you want to limit the liability of the general partner in a general partnership, I mean a limited partnership, then you create limited liability partnership. So this is same concept as a limited partnership, but the general partner here will not be liable for, will not be held personally liable. So if you create limited liability partnership. Now for professional association, from the word professional, so these are professionals who wanted to form an association. But this one is the list of the professionals that can form professional association is exclusive. So if you're not in the list, you can't form professional association. And we'll look into the list later on. So if you're not in the list and you want to form an association or a group or organize a business entity together, and you cannot form professional association, then you may form professional corporation. So here, from the word professional, you should be providing service, professional service to be professional, right? And when we say professional service, these are services that require you to obtain a license first before you can provide those services. For example, attorneys or engineers, doctors. You can't provide those services unless you have the necessary license. That makes it professional. Then you can make professional corporation. And when we say professional corporation, it doesn't have to be formed by more than one person. It can be formed by just one person. Just like in a limited liability company. You know. I think this is the superstar, the most famous type of business strategy, because I always hear this. Let's form LLC, limited liability company, because of the liability, the limitation on the liability. But when we say limited liability company, this is neither a partnership nor a corporation. It is a totally independent, unique entity that you can form. And of course, it has some, in order for you to form that, there are some types of formality that you have to comply under the law. Okay, so let's, again, I had mentioned about the S and the C corporation, and I feel like I need to identify or differentiate these two, because I have somebody asked, why is there an S or a C corporation? Why not just C corporation? Well, the default is C corporation. When you create a corporation, it is a C corporation. It becomes S corporation depending on how you chose to be taxed as a corporation. So for C corporation, there is double taxation. The corporation is taxed twice. The corporation, the business pays at the corporate level, and shareholders, who are the owners of the corporation, will also have to pay on their income tax or income received from the corporation. When you choose S to be taxed as S corporation, the S, by the way, came from the designation in the IRS code, which is subchapter S, which means that as a corporation, you chose to be taxed only once, and you're passing it on. It's like a flow through taxation, because you're passing the tax to the shareholders on the profits they receive from the corporation. But of course, the corporation still have to file a return. It's just that the shareholders are being taxed on the profits that they have received. And okay. And of course, if it's just a small corporation, then why not form S corporation? The maximum is 100 shareholders. If you exceed that and you want to offer your shares to the public, then you should be forming C corporation. You can issue shares to founders, employees, and investors, and even more than 100 shareholders. The other thing is that if it's an S corporation, there is a strict requirement as to the ownership. It can only be formed by domestically, but when the corporation is located in the United States, within the US, and the shareholders must be either US citizens or residents. So foreign corporation cannot most likely avail of the, be classified as S corporation. Okay, so, and that's just the distinction between the two. Okay, so let's go to how to register your business here in Texas, which is actually the bulk of our presentation for tonight. So we'll talk about business structure. So actually we kind of went over that already. We're just gonna go into a little more detail as to the differences between the different entities that we just talked about, that we discussed. Also the formation, how to form those business entities. We'll talk about the business name and the registration of your business, and a little of IRS, state and local agencies related to business formation, and also licenses and permits. Okay, so let's go to the first one, business structure. So again, we're just gonna focus our presentation or discussion to this 2, 4, 6, 7 business entities that we discussed earlier. Okay, for business structure, like I said a while ago, sole proprietorship, it can be formed by a single person, and there is no separate entity, which means that you are your business. Your business gets sued, then you're the one being sued actually, because it's not separate from you. Okay, and for a corporation, like I mentioned a while ago, the owners are called shareholders, and the corporation is distinct and separate entity from that of the shareholders. So if the corporation is sued, it's just the corporation being sued, not the shareholders. And when it comes to liability in a corporation, of course, there are some exceptions to that later on, but we're not going to be discussing that tonight. It's a little more it needs a deeper discussion as to the liability of the corporations. There's like a concept of piercing the veil, alter ego, and all that. So I just don't want to confuse you with those concepts. But a corporation has to have at least one director, because the director is the one who's must be an actual person and who will manage the business of the corporation. Okay. But the question is, can you avoid having a director? Can you have a corporation without a director or without board of directors? Yes, that's the answer to the question. Yes, you may. The shareholders can come up with or enter into a shareholder agreement that the corporation will be shareholders manage, or it's called shareholders management. But you have to definitely include that or annotate that on the certificate of stock, because it has something to do with, it affects when you sell your shares. Because some people will think that, oh, I don't want to be a part of a corporation that is managed by shareholders. I want a board of directors. So that's why it's required for you to make sure that it's disclosed when you share when you sell your shares of stock. Okay, and for general partnership, as I've mentioned earlier, there must be 2 or more individuals or entities. And when I say entities, it could be not a natural person, it could be a part of a general partnership. And there's no formality needed here. That's why I said that the 5 factors, the PICLC, are very important to determine whether there is a general partnership. Whether you form a general partnership. Again, the P is for your profit. If you as partners share profits among the partners, or not or, and the I is intent. If you have the intent to be a partner or to work as partners. The C is for control. If you have control or part of the management of the business. Or if you have, not or, I'm sorry, I always say or, and losses, if you share losses. And the last one is C, which is the your contribution to the partnership. And contribution may either be money or property. So if you have all those factors, then you can say that you form general partnership even though you did not file anything with the Secretary of State. It's a default partnership. And you may be held liable as a general partner if you transact business under the general partnership. Okay, now for limited partnership, there must be at least, it's a partnership, so at least there are two persons in the to form partnership. So in limited partnership, there must be at least one general partner and one or more limited partners. If there is, if it's all limited partners, then this is not limited partnership. That's something else, and we'll mention that again later when we discuss the business entity that is when all the partners are limited partners. But for limited partnership, there must be one general partner and one or two or more limited partners. For professional association, here's the list. So if you don't belong to any one of this, then you cannot form professional association. So who are these people? Doctors of medicine, doctors of osteopathy, podiatrists, mental health professionals, optometrists, therapeutic optometrists, chiropractors, dentists, or veterinarians. If you're any one of that and you want to form an association, you can form professional association. However, if you are not any one of these professionals, but you want to form an association, then you may form professional corporation. Although in a professional corporation, you don't have to be two or more. One person, one professional can form a professional corporation, providing professional.
No more na.
Please mute. Please mute if you're not speaking. Thank you.
Oh my God, what happened?
Okay, so continuing. So when you say professionals, you are providing professional service. I think I mentioned this earlier that professional service is before you provide that service, you are required to obtain a license, just like lawyers, doctors as well, dentists. If you need to obtain a license, then you can form a professional corporation if you wanted to form that kind of association or business entity. For limited liability company, the limited liability company, just like professional corporation, may only have one owner. You don't have to have more than one, but but it doesn't mean you can't. But if you have more than one owner, then all must be limited partners. So remember limited partnership. Limited partnership, there must be one general partner and one or more limited partners. But if you want everybody to be limited partners, then form limited liability company. Okay, so I have a brain check, by the way, just to see, because I know sometimes some people need short time, to absorb information. So this is my way of checking. As an educator myself, I always check whether my students are sleeping or not, listening or not. So here's my way of determining. So here's a question. And you can type yes, no, maybe in the chat box if you want to, answer the question. Here's the first question. Let me put this one up. Do I have to file a certificate of formation with the Secretary of State if I'm forming a general partner? So this is okay, hold on, let me see if this is the correct one. If I'm forming, so do I have to file a certificate of formation with the Secretary of State if I'm forming general partnership? What do you think? Yes, maybe, no? You can type your answer in the chat box and I'll look into it later. because since I'm presenting, I have to physically click the chat box to see. But if you answered no, then you are correct, because forming a general partnership does not require anything, any filing of any forms, or you don't have to do anything. You just need to prove that the 5 factors exist. Then you formed a general partnership. Okay. And here's the next question. Can I create a corporation even if I am the only owner of the business? Can I do that? Form a corporation if it's just me? Yes, maybe, no. If you answered yes, then you are correct. Remember a professional corporation? You can form professional corporation even if it's just you. Like a law firm. If there's only one lawyer there, that lawyer is a professional, him or herself, providing professional service, can create a corporation, professional corporation. So the answer is yes. Okay. All right, so we're finished with business structure. Let's go to formation. So again, for the formation of this business entities, the list that I have here, let's start with sole proprietorship. I mentioned a while ago, there's no formality. You can just start a business, open a mechanic shop, and there you go. Pay taxes, then you already created a sole proprietorship. Same goes with the general partnership. You don't need to file anything. There's no formality required. You can create general partnership as long as the 5 factors are present. For corporation, limited partnership, professional association, professional corporation, limited liability, all the rest, you need to file a certificate of formation with the Secretary of State. And you can do this online. Just go to their website and you'll be able to file a certificate of formation. Of course, you have to pay the required filing fee, filing fee, and you have to have registered agent and, of course, registered office address. For limited partnership, you have to have a partnership agreement, but you are not required to file that one with the Secretary of State. But it's important for you to have that because that will govern how your partnership, your business will be managed. For professional association, you can only register one type of professional service. If you are all doctors, then it's going to be a Medical Doctors Association. You can't mix and match, okay, although you're in the list. For limited liability company, you have to have an operating agreement. And just like in partnership agreement, you don't have to file this with the Secretary of State. Okay? So again, no formality for sole proprietorship and general partnership and all the rest. There are specific requirement of filing with the Secretary of State on the certificate of formation, and you have to have registered agents and address. Okay, so quick brain check again. Another question. Do I still have to file a certificate of formation with the Secretary of State if my partner and I wanted to form a limited partnership? So yes, maybe, or no. If you answered yes, you are correct. You have to file a certificate form. You have to file a certificate of formation in order for you to form a limited partnership, and that goes with the other with the corporation, with the limited LLC, limited liability corporation, and also professional corporation, professional what is that? Professional association. Okay. And another question. If I have a limited partnership, do I have to file our partnership agreement together with a certificate of formation with the Secretary of State? Yes, maybe, no. The answer is no, you don't have to file your partnership agreement with the Secretary of State. Only the certificate of formation is filed with the Secretary of State in order to form your limited partnership. Okay. Are you feeling good? Are you getting 100%? Right now you're A+. That's good. Let's go to the next one. So we're done with formation. Let's go to business name and registration, which is interesting topic. So for business name and registration, again, for all this type of business entity, I want you to take note that sole proprietorship and general partnership can operate using the owner's legal name. So for sole proprietorship, you can use your own legal name. For general partnership, you can use the names of the partners, the last name of the partners, and that's okay. You don't have to register. But if your sole proprietorship or general partnership is operating under an assumed name, then you have to file a certificate, an assumed name certificate or DBA with the county where your business is located here in Texas. Okay, and also if you don't have a physical brick and mortar business, you're just transacting online or basically just transacting everywhere in Texas, you don't have a business premise, then the requirement is you have to register in the county of in all the counties where you are transacting business under that assumed name. So you have to do that. And you will know why later on because you want to avoid some liabilities. Okay. But yes, so sole proprietorship, general partnership, if you're just going to use the legal name of the owners, that you're fine, you don't have to do anything. But under an assumed name, you have to register that. Okay. So, and for corporation, it's very specific. In the business name, you have to have the word corporation in it. So let's say, for example, the corporation is ABC. So that means the name of your corporation will be ABC Corporation. So you have to register this, of course, with the Secretary of State when you file your certificate of formation. Or if not, you don't want to use the word corporation, then you can use the word incorporated, ABC Incorporated. Or you can also use ABC Corp, ABC Inc. or INC. Or you can just put a CO, ABC Co. or CO, or LTD, short for limited, ABC LTD. Now, abbreviations may be used with or without punctuation. So you don't have to, make sure I have the dot there, the period. Now, as long as the name corporation, the word corporation, incorporated, corp, Inc., Co., and LTD, any one of those, you don't have to use all of them, just pick one. When you register your corporation, you have to have any one of those in the name of your business, okay? For limited partnership, you have to have the words limited partnership in the name of your business. So for example, ABC limited partnership. Or if you don't want to use the limited partnership words, then you can use limited or LP or LTD. Okay, limited, ABC limited, ABC LP, ABC LTD for limited partnership. So that's why when you look at the business name and you see that, oh, I already know this is a limited partnership business. If you see the word corporation, definitely it's corporation, right? If you see the word CO, then that means it's a corporation. If you see the word the letters LP in the business name, then that means that's a limited partnership. So those are the names. For professional association, you have to include the words professional association or association or associated or associates or ASOC or ASSN or PA. If you see any one of those in the name of the business, then you know it's a professional association. Okay. I'm going to ask a question later, so better remember this. All right, professional corporation, you have to have the words professional corporation. So ABC professional corporation, okay? Or you can just use ABC PC. Oh, that's all letters. like Aileen PC, or you can do that if it's a professional corporation. And for limited liability company, you have to have the words limited liability company in the name of the business. If you don't want the whole limited liability company, then you can use limited company or LLC, LC, LTD, CO, any one of those. If you include it in your business name, we know that you have a limited liability company, an LLC. Okay. All right, you want to take a look at it for a few seconds? Because I know, I have a question after this slide. Well, not really. After this slide, I have questions. Okay, so let's talk about some more details. I feel like these are important when you are actually registering the name of your business, okay, or choosing a name for your business. You definitely would want to search first if that name is already existing, especially if you are doing business under an assumed name, okay? So you want to make sure you are not using a name that's already been taken, because the Secretary of State, they will not do the search for you to see if that name is already existing. So you don't want to be held liable for whatever later on because you're using this, a name that has already been used by other company. Like for example, you cannot use the word Apple in your business name or as your business name, or Coca-Cola, or I don't know, Walmart, because you might be legally liable later on if you use those things. So just do a search, name search. They have that in the website of the Texas Secretary of State. Okay, but if you feel like, oh, definitely this is going to be a very unique name, then yeah, why not? You don't have to do the search. But for safety reason and to avoid liability, just do the name search. Now, what if you have in mind a business name, but you're not sure if your partners would like the name for the business, or you're not sure if that's the name of the business, the name you want your business to be using for, I don't know, 10 years, right? Then, but you don't want, you want to reserve that name. You can also reserve that name. You can file a name reservation form with the Secretary of State, and that name will be reserved for you for 120 days. After that, then anybody can use that name, or unless, of course, you register before the expiration of 120 days. Okay. Now, for effectivity of formation of it's different from registering the name of your business or reserving the name of your business from registering your business by filing certificate of formation, because if it's a corporation, LLC, LP, LLP, you have to file a certificate of formation with the name already of your business there, right? Once you file that certificate and it's accepted by the Secretary of State, that business is already existing, okay, legally existing already. But you have like a 90-day period to delay the effectivity if you want to delay the effectivity of the formation of your business. I said up to 90 days because you can choose 30 days, 60 days, as long as it's not beyond 90 days. You can delay the effectivity of formation. Why would you do that? For a lot of reasons, right? You're not ready for it yet, or you're something to do with legal action, or whatever reason. But you can delay the effectivity of the formation of your business. Now, what is the effect of filing your certificate of formation with the Secretary of State? Of course, like I have mentioned just a few seconds ago, the business becomes existing. So that means that you can transact business, you can be sued, and you can sue under the business name once it's already been filed, unless, of course, you delay the formation of that. Okay. Now, for duration of DBA, assumed name. So how long can you use an assumed name once you have registered it? Anybody, any idea? So just type in the chat box. I'll look into it later, promise. Well, the effect is you can, the effectivity is 10 years. So once you filed or registered your name under an assumed name or DBA, you can use that one for 10 years. Now, can you extend that? Yes, definitely, as long as you renew it within 6 months from the expiration. Okay. Now, if you don't, of course, definitely it will be abandoned. So that goes with the to the next line there, abandoning assumed name. Can you abandon an assumed name? Well, yes, I just mentioned it. If you don't renew it, then that's abandoned. Anybody can use that name. But if it's within 10 years, because it has a 10-year duration, and you don't like the name of your business anymore, or it's not really generating business, it's the name is so not business enticing, I don't know. You just want to change it, maybe change of management. Yes, you can abandon the assumed name. You can change that. You can abandon it by filing an abandoning assumed name form with the Secretary of State. So don't think that, oh gosh, the name of our business, this is really not generating business because of the name. Then don't worry, you can change it. Okay. You don't have to endure it for 10 years. Now, what if you did not comply with the registration? What is the effect? Like, for example, you're doing business under an assumed name and nobody told you have to register that. Or you know you have to register, but you're procrastinating for some reason. So what is the effect? Well, actually, if you don't comply with the required registration, you can be held civilly and criminally liable. So there could be some civil and criminal penalties. It's actually considered a type A misdemeanor, or yeah, if you don't comply with the required registration. Okay. What about foreign entities? Are they required to register? Well, foreign entities and domestic entities doing business under an assumed name, is required to register under assumed name or comply with the DBA, get that certification. Okay. All right. So brain check again. I hope you remembered something because this is how I check it, and this is how you check it as well. Is my brain working right now? Okay, so sorry about the names. If you don't like them, just bear with me. I couldn't think of any names. It's not just a disclaimer, not necessarily a fan, but I don't know why. I was listening to the music a while ago. Anyway, can Taylor Swift and Justin Bieber form a professional corporation in Texas called Just a Talent Show? Yes, maybe, no. What do you think? The answer is no. If you said yes, maybe you focus on the assumed name, Just a Talent Show. You forgot to consider professional corporation. Remember, to be a professional corporation, you have to be professionals. You must be offering professional service. And I don't think you need a license to be a singer, right? You don't have to take a state exam and get a license before you can be a singer. All you need to have is a talent, right? So the answer is no. You don't have they cannot form professional corporations simply because they are not considered professionals. They can sing without obtaining a license. Just imagine if you need to obtain a license before you can sing. I don't know if that's a good thing. Okay. Next question. And I have one more question here. Okay, if I start an auto repair shop called Dizon's Automotive, do I have to file a DBA certificate or an assumed name certificate? Yes, maybe, no. What do you think? Dizon's Automotive. Although I don't know how to really do some mechanical work in a car. I don't know anything about car. I just know how to drive it. But yeah, the answer here is no. I don't have to file an assumed name certificate because why? Because I use my last name. Remember, I use my last name in the name of the business, Dizon's Automotive. So I don't have. I can go ahead and transact business without filing an assumed name certificate. If I use maybe Aloha Automotive or XYZ Automotive, then I have to file a assumed name certificate. Okay, so I hope you're remembering this because I know it's a lot of information to take. Let's see if I have more time. Okay, IRS, state and local agencies. So here, I just want to point out some important information that I think it's important for you to know in terms of IRS, state and local agencies. If you're dealing with these agencies and either state or federal, if you hire, so whatever business entity you formed, if you are hiring employees, you may need to register for EIN, employer identification number with IRS, even if you with IRS. Now, if you hire, you have to, I think, because you are filing taxes, and then your employees later on will be filing unemployment benefits, and you make sure you comply with this requirement. And also, if you are transacting or opening a bank account, you need to have EIN. Now, this one is interesting. If you're an out-of-state sellers or remote sellers soliciting business in Texas, that means you have no physical presence in Texas. Maybe you are in Maryland selling your products online. When you say remote sellers, it could either be through online, internet, phone, if they're still selling products over the phone, or television, and you are soliciting business here in Texas, then this might apply for to you. Like you may register for sales and use tax permit. But I want to make a clarification here, because right now a lot of people are selling products online through a we call it marketplace provider. When we say marketplace provider, I'm talking about like it's like Amazon, eBay. So you can post your products there and sell it, transact business through Amazon. So you are considered online seller if you don't have physical presence in Texas. Then I want to make a clarification here. If you are selling through marketplace provider like Amazon, if Amazon issued a certification that they are assuming the responsibility of obtaining sales and use tax permit here in Texas, then you don't have to do this. Okay, you don't have to obtain sales and use tax permit in Texas. But if they did not, or even if they're actually doing it, but they did not issue certification to you, that means you're not sure if they're doing it, you better register for sales and use tax permit. Okay, but there is again an exception to this rule, which we call safe harbor rule. That means if your total revenue is for the last 12 months, when I say total revenue out of from transaction only in Texas, then you don't have to, you're excused from obtaining sales and use tax permit. So again, remember that 500,000 there. If it's less than that, you don't have to. But if it's more than that, and Amazon did not certify that they're assuming the responsibility, then you have to register for a sales and use tax permit in Texas. Okay, that is for out of state or remote seller. Now, what about if you are a Texas seller? I did not include it here, but if you are a Texas seller, definitely you need to, that means you are physically present here in Texas conducting business, then you need to register for sales and use tax permit. you're not included in a safe harbor rule. So it doesn't matter how much your income or total revenue for the last 12 months, you have to register if you're a Texas seller. Okay. Now, for franchise tax, this is imposed on taxable entities only. And what are these entities? I'm talking about the LP, limited partnership, corporation, limited liability corporation, company, professional association. The threshold is 1,180,000. If you didn't reach that, then you don't have to pay for franchise tax. Exception here, even if you're earning more than that, if you are sole proprietorship or general partnership, you are not considered non-taxable entity, so you don't have to think about, franchise tax. Okay, so if you want to know more about it, you can go to the Texas Controller website, or you can go to Austin and inquire if you're not sure. Okay. All right. So we're done with IRS, state, and local agencies. Let's go to licenses and permits. This is when we say licenses and permits, I just want to go over it quickly because there's a lot of licenses and permits that are required if you are doing, depending on the type of business you are doing here in Texas. Okay. But make sure that you ensure that all permitting requirements are met at the local level. So you have to check with your county and city government. Like, for example, if you're if you're a business entity operating a restaurant, you should know whether the permits are needed for you to be able to operate legally. I'll share with you a link later on, like a comprehensive list, because it, like I said, it depends on the business that you are doing in Texas. So that's the business comprehensive permit guide that I'll share with you later. For federal license or permit, like, for example, you're selling alcoholic beverages in your business premise. So you have to make sure you comply with the required licenses, because that is regulated by federal agency. So if you're not sure, you can always check Texas Controller website or the Texas Occupation Licenses and Permits and SBA. And this is just an example. So I just want to show you that, like, for example, if you're doing wholesale distribution, these are the type of licenses. It depends on what you're doing in your business, what service you're providing. So there's just, it's very, they're very specific. Okay. So yeah, we finished licenses and permits. Brain check, if you're still there. If I'm a Texas seller selling products through Amazon, do I still have to obtain a Texas tax permit and file sales and use tax return? Yes, maybe, no. The answer is yes. And I have mentioned a while ago, even if you are not covered by the safe harbor rule. So if you're a Texas seller, which means you are physically located in Texas, doing business in Texas, you still have to obtain a Texas tax permit. Okay. And also you have to file your return, declare your files. You have to file sales and use tax return as well. Another question, if I'm a Maryland seller selling products through Amazon, so I'm out of state now, do I have to hold a Texas tax permit if I have customers in Texas? Yes, maybe, no. You still remember the answer is maybe, because it depends. Remember, it depends on whether Amazon assumed the responsibility or not. If they assume it, you don't have to. But if they did not assume it, you may have to if your gross revenue for the past 12 months exceeds the threshold, or if it's how much is it again? Who can tell me how much is the threshold? 500,000? Okay, so anyway, this is just a warning for out of state, because I've heard it this one many times, like, oh, I'm not in Texas and I just transacted business in Texas. One time I just sold one item in Texas. So I cannot be sued by a Texan because I don't have an address in Texas. I'm a registered agent in Texas. So how can the Texas court acquire jurisdiction? Now, I just want to let you know there's this called Texas long arm statute. You know, that Texas jurisdiction can reach out to you, but it's very specific. You have to purposely avail benefits and protection of the Texas law by establishing your minimum contacts in Texas. So that means that we're only looking at the seller's sole action. We don't care if the buyer intended to buy from you, but if the seller intended to sell products in Texas and it's purposeful, not random, you really targeted Texas or customers in Texas, then the Texas long arm statute may apply to you. The buyer can sue you, and if you don't pay correct tax in Texas, if you owe taxes, then you can also be sued, even if you are out of state. So Texas long arm statute. Okay, I don't know if I have time to talk about this case. Well, this is just a summary. Why do we need to legalize our business? Of course, because of your tax obligation, to determine your personal liability and to avoid legal issues. And of course, if there are already legal issues developing, you want to know how to proceed from there. And this is one example of business litigation that involved interpretation of whether the parties created partnership or not. So here the court actually applied the 5 factors test and totality of circumstances. Here the father and son formed a partnership, but when they were sued for breach of contract, the plaintiff included the wife because the plaintiff thought that the wife is also a partner. So applying the 5 factors test, the court said, no, the wife is not a partner, so she is not liable at all because she did not share in the profits. She did not intend to be a partner. She did not share with the losses, and she did not contribute anything in the partnership, so she cannot be considered a partner. But for this case, this one, marriage of Armstrong, here what happened here was that the court, there was a divorce case, and the court awarded the real estate property to the wife and the former wife. The husband, Ronald here, is contesting that. He said that, oh, this is not part of the community property. It is actually owned by the partnership. So the court has to establish whether a partnership existed, because Ronald claimed that there's a general partnership formed by him and the former mother-in-law. The court said no, applying the 5 test rule. No, there's no partnership at all, because there's no sharing of profits, no losses, sharing of losses, no intent to be a partner. Okay. All right, so there's no more question. I just want to let you know that today in this presentation, we identified the common types of business structure. We learned how to register a business in Texas, and hopefully you understood the importance of legalizing a business here in Texas. So we finished all that. Hopefully you learned something. And if we are going to help you, let's say, form a business here in Texas, these are the things that we usually prepare for you. We prepare and file the certificate of formation, we addendum and certificate of formation, prepare the company agreement for you. We prepare the membership interest and unanimous written consent. We will also obtain the employer identification number for you. We will prepare a letter of instruction to the officers of the business entity to guide, of course, in collaboration with the members. And also, we will prepare a letter of resignation of the organizer. The organizer here is us because we form the business for you. So we have to resign because we're not part of the business. So that's part of it. And that's just my presentation. Thank you for staying with me.